Okay, welcome back to another video on A-level law. Today we're going to be talking about involuntary manslaughter. So make sure you distinguish this from voluntary manslaughter. Voluntary manslaughter is a different topic, and that's made up of the two partial offences, diminished responsibility and loss of control. Involuntary manslaughter that we're talking about today, that is an offence. It's where you've killed someone, usually through some sort of accident or mistake or something like that, or you were committing a crime and that's what led to something. We'll explore that in more depth today. Two main types of manslaughter we're going to look at. There are others, so just be aware of that. But the two we're going to look at today is unlawful act manslaughter on the left there and gross negligence manslaughter on the right. And you can see the test there, which we'll go through in more depth today. They're both indictable, which means they're tried in the Crown Court. And the maximum sentence for both of them is discretionary life, which means the judge can give a life sentence, but can give anything below. 9 times out of 10, if not more than that, it will be a custodial sentence, because essentially you have taken a life and they need to reflect that in the sentence. We're going to start with unlawful act manslaughter. So you can see the test there on the left. So D must have done an unlawful act that's dangerous. They must have caused the death, and they must have the mens rea for the unlawful act. And as you can see again, it is indictable and carries a discretionary life sentence. So we're going to start off by looking at unlawful act. There has to be an unlawful act to be guilty of unlawful act manslaughter. The name's in the title really, so it kind of gives it away. Lamb is a good case to illustrate this. So in Lamb, two boys were playing a revolver and one of them accidentally shot the other. Essentially, there was no unlawful act. The kid hadn't committed a crime. You kind of got to get past the fact that he shot his mate, and that seems a bit weird, but just go with it. You know, essentially, there was no unlawful act. He didn't do it on purpose or anything like that. It was just clearly a mistake. So he couldn't be guilty of unlawful act manslaughter. Another case to look at that illustrates that there has to be an unlawful act. Slingsby, a bit more adult themes. If you go and have a look at it, be aware of that. But it's another case that does illustrate that. He couldn't be guilty of unlawful act manslaughter in that case. It has to be a criminal offence. It can't just be something, a civil wrong. So in Franklin, he chucked a box off a pier. It was in the 1800s, and that wasn't a crime at that point. The box landed and killed a swimmer, but he hadn't committed a criminal offence, so therefore he hadn't done an unlawful act, so therefore couldn't be guilty of unlawful act manslaughter. Equally, if we look at Lowe, it has to be an unlawful act. So in Lowe, he failed to take his child to the hospital. That's an omission. Omission is where you failed to do something, not where an act is where you positively do something. So, you know, for unlawful act manslaughter, it has to be an act, not an omission. Bear in mind, Lowe could, of course, be guilty of the other one, which is gross negligence manslaughter. So bear that in mind. He didn't get off completely, but he couldn't be guilty of unlawful act manslaughter because he'd done an omission. So bear that in mind. That's sort of like the easy first bit. The more complicated part of this offence is the second part, which is the act has to be dangerous. Now, obviously, we all have our interpretations of dangerous, but the actual legal interpretation of what that means comes from the case of Church. Now, in Church, the facts are irrelevant, really, but I'll tell you the facts. I think he was arguing with his girlfriend. He knocked her unconscious. They got in a fight. He knocked her unconscious. He tried to resuscitate her for about 30 minutes. He thought she was dead, so he tried to dispose of the body by chucking it in a river, where she actually then drowned. She actually wasn't dead. So kind of bad luck, really, for him, but equally, you know, tough luck in the fact that he has killed her. And the test is, whether it's dangerous, is would the ordinary and sober person realise the risk of some harm from the defendant's unlawful act? And if they would, then it's classed as dangerous. And that's the legal test they use. So would the ordinary sober person realise the risk of some harm from the defendant's unlawful act? So that's the main case on it. So whenever you're looking at unlawful act manslaughter, you must apply the Church test to determine whether the act is dangerous, because that's the key thing. You can't just say, oh, it's dangerous because X, Y, Z. You need to apply the Church test. There's been lots of cases where people have tried to get around this. So there's a few other cases we need to look at. The first one, and the first point here, is the act doesn't have to be aimed at the person who dies. It can still be classed as dangerous, even if your act is aimed at someone and then someone else dies from your action. Now we can see that in two cases, Larkin and Mitchell. Larkin, very strange case. A man was threatening another man with a razor blade, and a woman tried to intervene. I think she was the girlfriend of one of them, and she fell on the razor blade and sort of slit her throat open, which sounds fairly dramatic and crazy that would happen, but that's pretty much what happened. And although he was threatening the man, the act was aimed at the man, and the woman was the person that died, it didn't matter. So the unlawful act doesn't have to be aimed at the person who died for it to still be classed as dangerous. You know, if you're threatening someone with a razor blade, someone clearly could fall on that, so therefore it's classed as dangerous generally. Equally in Mitchell, so in this case, he was arguing with a man in the queue, in a post office queue. He pushed the man, and this man fell into an old lady who then fell over and died. Now again, his act, his unlawful act, wasn't aimed at the lady who died, but it's still classed as dangerous because it clearly could affect other people, and clearly did in that case. Equally, we saw from Goodfellow, the act can also be aimed against property. The act can still be classed as dangerous, even if it's not aimed at the specific person that died. It was aimed perhaps at property. And in Goodfellow, it's an arson case. We set fire to a house, and then it burnt down and killed a person. So same sort of thing there. It doesn't have to be aimed at the person who actually dies necessarily. It has to be the risk of some physical harm. So we call Dawson and Watson the heart attack cases. Because in both of these, the people actually died of a heart attack. So in Dawson, they were robbing a store, and they broke in, they kind of peered in, and the shop assistant had a heart attack and died from the shock, presumably. Now, the court said the ordinary sober person wouldn't realise the risk of someone having a heart attack. The question is, would you realise the risk of some physical harm being done against somebody, not would someone have a heart attack? So they said the act couldn't be classed as dangerous in that case, and therefore they weren't guilty of unlawful act manslaughter. They were obviously guilty of robbery and things like that in that case, but not unlawful act manslaughter. You can contrast that with the case decision in Watson. So in Watson, someone broke into an old man's house. He had a heart attack and died 30 minutes later. This court sort of went on a different trajectory with this one and sort of said, well, if it's the frailty of the person, the weakness of the person is obvious, then actually you could say that the ordinary sober person would realise the risk of some harm in that case, because actually they would realise a frail person could have a heart attack. But bear in mind, both of these cases still fail on causation, because it's very difficult, if not impossible, to prove that their actions caused the heart attack, because obviously you could run into loads of things there about like heart problems with the heart, alcoholism, obesity, all sorts of things that could be the cause, and how could you tell that the shock actually caused it in that instance? But whether we'll explore that, we'll explore that in AO3, but whether the courts will go down that route in a bit more detail in due course, maybe they will. Causation, obviously the same rules. If you've watched the murder video, the same rules of causation applies to there. There's three key rules of causation. You have to prove all three. The first one is factual causation, and they use the but-for test from Paget or White there. And the but-for test is, but for the defendant's actions, would the victim be dead? So if they hadn't have done what they did, would the victim be dead? So Paget, just as a reminder here, he held his pregnant girlfriend hostage and the police shot her. If he hadn't have, but for his actions of holding her hostage, he wouldn't be dead. So if he hadn't have done what he did, she wouldn't have been shot and be dead. So therefore he was the factual cause. In White, he tried to poison his mum, but his mum had a heart attack before she drank the poison. So in that case, but for his actions, she would have died anyway. So it's the opposite actually. So actually he didn't factually cause her death. So just bear in mind, Paget and White are sort of opposite uses of the but-for test. You also have to prove legal causation, and this comes from the Kimsey test. It used to be the de minimis principle, so bear in mind that's changed now, quite a long time ago, but still be careful with that. And the question is there more than a slight or trifling link between D's actions and the victim's death? D remembers the defendant. If there is, then obviously you have legal causation. And remember, Kimsey was a racing case. They were racing each other and one crashed into a tree and died. Finally, there has to be no intervening acts. There are a couple of important things that can come up in manslaughter that are particularly relevant. They're around doctor third-party intervening acts, which are particularly quite often come up in the exam. Jordan's a really good case for that. So Jordan, the victim in this case, was actually recovering in hospital from a gunshot or a stab wound, one of the two, and the doctor came in and prescribed him antibiotics. And he had an allergic reaction to those antibiotics. So they made a note on the thing: don't get onto his record. Don't give him these antibiotics because he has an allergic reaction. Jordan came in, or the doctor in this case, and gave him a massive dose without checking the notes, and he died from the allergic reaction. Now his wound had pretty much healed up, so actually he clearly died from the allergic reaction in that case. And they said that doctor broke the chain of causation, meaning the person that stabbed him or shot him and put him in the hospital in the first place is no longer liable for manslaughter in this case, or murder or anything like that, because they didn't cause the death, because there's an intervening act. So we talk about the break in the chain of causation. Also bear in mind that turning off a live sport machine, as we saw from Malsharek, is not an intervening act, so that doesn't break the chain of causation, so you've got to be careful with that one. Finally, you have to have the mens rea for the unlawful act. So we could see this in Newbury and Jones. In Newbury and Jones, they were chucking paving slabs off of a railway bridge onto the train tracks, and one of the paving stones fell onto the train and killed one of the train guards. Did they have? Obviously, they didn't. They said they didn't intend death, or they didn't even foresee death or any harm whatsoever. But the question is, did they have the mens rea for the unlawful act that they were doing? And the unlawful act they were doing in this case was criminal damage or unlawful damage, and they did have the mens rea for that. They were being reckless, so therefore they were guilty. And there is some controversy around that. You know, the fact there is no need to foresee death or even harm. But we'll talk about that in the AO3. Moving on to gross negligence manslaughter now. Gross negligence manslaughter, the test came from a case called Adamaco. It originally was 4 parts. You can see duty of care, breach of duty, causation and grossly negligent on the left. And a case called Misery and Another added the 5th part, which is risk of death, and onto it much later. So just bear that in mind. Adamaco gives the main definition, but it was added to by Misery and Another. Again, it's indictable and carries a discretionary life sentence. So let's explore each of these parts again. So duty of care, there has to be a duty of care for D to be liable. Now, you'll get, if you've done negligence yet, or when you go on to study negligence later on the course under tort law, it's very easy to get these confused because negligence has duty of care in it as well. So make sure you treat them as separate areas of law, because remember, they don't, civil and criminal law don't bind each other. So they are separate areas of law. So don't get confused here and start talking about civil law and vice versa. When you do tort law, don't be talking about criminal law there. So you've got a couple of key ones here that tend to come up in exams. Contractual duty, for instance, doctor to a patient. We can see that in the case of Adamaco. So just go through what happened in Adamaco. It was an anaesthetist, so if you can try and spell that, a doctor who delivers anaesthetic in an operation. They hooked her up to a breathing machine operative thing, and he failed to notice the breathing tube came loose. The machine was beeping, she went blue and purple, and he failed to notice till it was too late. She got brain damage and died a couple of months later. And he was held to have a contractual duty because of his job as a doctor to patient. Equally, in DPPV and duties, you can see that drivers owe pedestrians and other drivers a duty of care as well. There are others, so you've got duty because of relationships, so that's parents to children, which you can see in Gibbs and Proctor, and you can also see spouse to spouse in R.V. Smith. Which shows, so spouse to spouse is sort of husband to wife, or wife to husband, or husband to husband, or wife to wife, that sort of aspect. There are others, so duty taken on voluntarily. You can see that in Stone and Dobinson, where they care for their eccentric aunt, and they take on her care and then became liable for when they didn't feed her and then she died. So you can take on a duty voluntarily. And there are others around like statutory duties where Act of Parliament says you have a duty of care and things like that. So you can have a look at those online. All the duties are clearly laid out. You have to breach that duty. So D must have done something wrong, i.e. they breached their duty of care. So you don't have to, there's no sort of real cases on this. If you look at Adamaco, for instance, he breached his duty of care by failing to notice the breathing tube came loose. So just bear that in mind. It's also worth mentioning, if we just go back a second to duty, there is a case called Wacker, so RV Wacker, that's Wacker. This was a human trafficking case. He agreed to smuggle 60 illegal immigrants into the country. 58 of them unfortunately died during the ferry passage. And the question was whether he could be liable. The first question is, obviously, did he have a duty of care? And the normal rule is, of course, criminals don't owe other criminals a duty of care, because how could you put a legal duty on an illegal thing, an unlawful thing? But in Wacker, because of the gravity of the case and the fact that he had essentially killed 58 people, they did determine that there was a duty of care, and that's something worth mentioning in Area 3, which we'll talk about later. So we've covered breach. Obviously, the same rules of causation apply. I'm not going to go through those in detail because we've already done that. It's exactly the same 3 rules: factual causation, which is the but-for test; legal causation, the Kimsey test; and there are no intervening acts. So it's the same rules as for UAM. And obviously, in a scenario, if you're writing this, you certainly wouldn't write this out again if you were covering both Unlawful Act Manslaughter and GNM. Notice there that UAM is obviously shorthand for Unlawful Act Manslaughter. Shorthand for gross negligence manslaughter is GNM. So if you do that in the exam, make sure you write it out first, and then in brackets put UAM, and then you can refer to it as UAM or GNM for gross negligence manslaughter for the rest of the paper. So make sure you go through the same rules of causation for that. Like I said in the scenario, don't write it all out again, just say it's the same rules as for UAM if you've already written those out. In terms of what grossly negligent is, there's no real definition of what grossly negligent is. All we know is that it can't just be negligent. So in Bateman and Finlay, they were negligent only. So Bateman, she was having a home birth and her uterus prolapsed, it sort of came out basically. The doctor didn't send her to hospital for 5 days, she got an infection and died. It was 1925, so bear in mind that that was classed as negligent only. It wouldn't be, it would probably be grossly negligent today. But it was negligent only at that time because of medical knowledge and understanding and sort of treatment at that time. So it was only negligent, so he couldn't be liable for gross negligence manslaughter, the doctor in that case. Finlay, they took a sort of, I think it was a scout expedition up Mount Snowdon in Wales, and they followed most of the safety precautions, but not all of them, and one of the children fell off the mountain and died. And they again said they weren't grossly negligent, they were negligent only as they followed most of the safety precautions. Cases that show gross negligence, obviously Adamaco and DPP v Andrews, which we've already talked about. Adamaco feigned to notice that breathing tube coming loose, was grossly negligent. It's worth mentioning as well, before we go on to risk of death, that Lord Mackay has come up with a definition which is so bad as to be criminal. And that's a useful one to use in the exam. So Lord Mackay, so bad as to be criminal. It is a circular definition. We'll talk about that again in the A3, so it'll come up again. But it's not particularly useful in terms of actually really setting out what gross negligence is. Risk of death, as I said, this was added by Miser and Another. So in Miser and Another, 2 doctors failed to spot an infection in the knee after a knee operation and the person died. And they actually argued in the case that they shouldn't be liable for gross negligence manslaughter because the law was unclear. It was unclear as to whether the law required a risk of harm or a risk of death. And they clarified this area of law and said there has to be a risk of death in the case from the situation. So just be clear with that, it is now a risk of death, and that's clarified the law. So finally, there is another type of manslaughter which you could consider, which is reckless manslaughter. It was thought after Adamaco that this no longer existed, but then came along a case called Lidar, which I think was about 2002, early 2000s. And Lidar, basically, they were having a fight. They came out of the pub into the street. One of them got into the van, or the defendant got into the van, and the victim reached through the window. The defendant drove off at speed, and the victim was pulled below the wheels, basically, and died. For some reason, he wasn't convicted of gross negligence manslaughter, which he could have, because all road users owe pedestrians and other people duty of care, so he could have been guilty of gross negligence manslaughter, potentially even unlawful act manslaughter, but they chose to convict him of reckless manslaughter instead, therefore showing that reckless manslaughter still exists as a viable offence. And again, we'll talk about that in the A3. So talking of which, for an essay, obviously this topic has to be evaluated. The first big concern is that manslaughter is far too wide. If you look at several cases here, so how can Cato, just bear in mind we haven't talked about that deliberately or directly. Cato was a case where he injected or they injected each other with heroin and then one of them died. So he was liable for unlawful act manslaughter in that case because he had done an unlawful act of injecting someone with heroin. Under the church test for dangerous, the reasonable sober person would realise a risk of some physical harm from injecting someone with heroin. He did cause death. You go through the 3 parts, for causation. And he had the mens rea for injecting him with heroin, which was an offence under OPA, which is administering a noxious thing. I think it's section 23 of the Offences Against the Person Act. So Cato was liable. So in that case, we're going to the idea about manslaughter being too wide. Cato, he injected someone with heroin and they died. Compare that to Mitchell, where he pushed someone in the queue, he fell into an old lady who then died. Jordan gave a massive dose of antibiotics without checking the list, but it was a doctor. And Adamaco made a huge mistake as a doctor as well. These are all convicted of manslaughter, and yes, they are convicted of UAM or GNM different, but they are all convicted of manslaughter still, which carries the same sentence essentially and the same stigma. Is that too wide? Are they really different things? They've got different levels of blameworthiness, really. Injecting someone with heroin is very different to making a mistake as a doctor, perhaps. So you've got to bear that in mind. But remember that it does carry a discretionary life sentence, which gives the judge the power to sort of adjust the sentence respectively to what they've done. So certainly Cato probably would have got a much worse sentence than Jordan or Adamaco, for instance. So bear that in mind as well. Moving on to the church test. The church test is obviously, it uses the word what a reasonable and sober person would realise the risk of some harm. Obviously, always the question there is, well, who is a reasonable person? It's highly subjective, meaning people are going to have different opinions. And when you have different opinions, juries are going to make different decisions for the like-for-like cases, which therefore creates uncertainty and unfairness, and people should be treated the same way. And that uncertainty makes it difficult for lawyers to predict as well, and to advise clients about, what they should do, whether they should plead guilty or not, and whether they're likely to say that this is dangerous, the act was dangerous or not, and whether they're likely to be acquitted or found guilty. Which can make a lawyer's job quite difficult if the law is uncertain there in terms of predicting it and the relevant result. So bear that in mind with the Church test. There is obviously, as I said, still uncertainty around the heart attack cases, Dawson and Watson. They both still fail because of the rules of causation, but Watson seems to suggest that actually would be okay to convict for unlawful act manslaughter, whereas Dawson was absolutely not for heart attack cases. It is difficult because you think, well, it seems a bit of a coincidence that these people had a heart attack at the time. Surely they did cause the death. But until you can prove that categorically, it seems very difficult to actually convict someone beyond reasonable doubt, perhaps. 4, general issues around causation. Obviously, with any hospital setting, you're looking at multiple actors being involved in the treatment of someone. So how can you then narrow it down and say it is a single person, single doctor or nurse's fault if that person therefore dies? Equally, there are multiple causes for deaths. It might not always be one thing. So there are general issues around causation and proof there. 5, the drug cases. So again, I've not mentioned these deliberately. I've just explained Cato to you early on. Kennedy was where he gave someone heroin and then the guy self-injected, and the court said the person supplying the heroin was not liable for unlawful act manslaughter or gross negligence manslaughter, certainly not unlawful act manslaughter because it was an intervening act by the person deciding to self-inject. Rogers is the most relevant case here I want to look at. Rogers, he held the tourniquet around someone's arm while he injected heroin. So a tourniquet was like a tight elastic band to bring out the veins. And obviously under the law, you can be found guilty for what's called joint involvement, which is where you're basically jointly involved in the death and you can therefore be found liable for manslaughter through that. In Rogers, the question was whether this guy that held the tourniquet could be liable for manslaughter through joint involvement. And the court said no. They said holding a tourniquet was not joint involvement, which essentially rules out anyone being found liable for that, where they're helping someone inject heroin and being found liable for that if the person then dies. Because if holding a tourniquet is not joint involvement, then it's hard to see what else is. So there's some uncertainty there around joint involvement around drug cases, and the courts could certainly deal with clarifying that. And certainly they could have gone further and said, well, actually it is unlawful act manslaughter. Would that act as a deterrent for people supplying drugs and things? Maybe, possibly not, but it's something to consider. Number 6, the fact that there's no requirement to foresee even harm, let alone death for unlawful act manslaughter, as we saw in Newbury and Jones. They were chucking the paving stones off the slab, said we never foresaw death or even harm. Is it fair to convict someone for a very serious, one of the most serious offences, in fact, and carries a very high sentence, and very big stigma as well for manslaughter, in the fact that they never even potentially even foresaw harm? For this, you can look at something called the correspondence principle, and the correspondence principle is basically around the ideas, it's very simplified, but that the mens rea should reflect the seriousness of the offence. In this case, you'd say it doesn't meet the correspondence principle because the mens rea is obviously virtually nothing or very low for a very, very serious offence. 7, Wacker, as I mentioned earlier, the human trafficking case. Have they extended the duty of care between criminals now? They clearly did this case based on public policy. It was in the public's best interest to say, well, actually, you're convicting this guy. He had killed 58 people through what he did. Public opinion is obviously very strongly in favour of prosecution. But the question is, does that apply to all criminals now, or is it just human trafficking cases? So they have created some more uncertainty by sort of opening that up. Number 8, what's the difference between negligence and gross negligence? Obviously, there's no clear definition apart from Lord Mackay's so bad as to be criminal, which is actually a circular definition. It's criminal if it's so bad as to be criminal. So it doesn't actually really work as a definition. Certainly we could do with some clarity, perhaps a statutory definition. Remember, all of this law is common law based, so you get the same sort of issues around separation of powers, parliamentary supremacy, judicial lawmaking. Because it is all common law, it's not set out by statute. And given that it carries such a high sentence and is such a serious offence, should it not really be covered by statute? So in the same way that murder, really should be as well, but it's not. Equally, obviously, if you prosecute doctors and make the law too wide that you can prosecute doctors really easily, you might encourage doctors to pursue what's called defensive medicine, where they avoid taking risks, which could actually help a patient and things like that. So, and it would also be quite hard to recruit. If you look at the negligence video, which should be coming up soon, it talks quite a lot there about compensation culture and the effects of compensation culture, including defensive medicine. We'll talk more depth about that there, although that is an area of tort, but also bear that in mind. Positive, number 9, Misra and another did clarify the law around risk of death versus risk of harm. They said it has to be a risk of death. That's a good positive in the law. They've reduced the uncertainty in the law, so that's a big positive. And number 10, finally, reckless manslaughter. Is there a need for this offence? Lidar confirmed that it still existed after Atomeko sort of suggesting that it maybe didn't. Obviously, in Lidar, he could have been convicted of unlawful act manslaughter or gross negligence manslaughter, probably. So why did they maintain and convict him of reckless manslaughter? The flip side to this argument is, of course, well, it serves as a good backup offence if you can't get someone for UAM or GNM, perhaps, so because it's fairly easy to prove compared to the other two. So bear that in mind. Finally, scenario. It's quite likely in a scenario that it would involve a UAM, so unlawful act manslaughter, and a gross negligence manslaughter, although it's not guaranteed. It could be just UAM or just GNM, so we really don't know at this stage. There could be multiple examples of that offence, so 2 or 3. So if it did appear as just unlawful act manslaughter, you'd probably be looking at 2 examples of it, maybe, although it depends. We haven't seen many examples of this yet. With the combined UAM-GNM question, make sure you consider issues around any intervening acts. Quite often what we've seen in old specifications or old or model example questions is they'll start off with a UAM and then there could be a GNM by a doctor towards the end. So obviously consider that the GNM by the doctor could be an intervening act, meaning that the person at the beginning is not guilty of unlawful act manslaughter, if you follow what I just said. So make sure you methodically apply the tests. So if you're doing unlawful act manslaughter, make sure you look at unlawful act first, then consider the church test for dangerous, then consider the 3 rules of causation, the but-for test, Kimsey, intervening act part, and then consider whether they had the mens rea for the unlawful act. So see how methodically I did that. Make sure you're going through each part saying why it's met and then coming to a conclusion. And same with GNM, make sure you go through each part of the 5-part test and reach a conclusion. Hope you found that useful, and more videos coming up soon. Hit subscribe if you find these videos useful, and thank you for listening. Cheers.